Most people think they understand what bankruptcy means. They picture empty accounts, frozen assets, closed businesses, a financial collapse reduced to a number on a court document. That picture is incomplete. And in many disputes, it is dangerously incomplete. Because bankruptcy is not simply a financial event. At a structural level, at the level that actually determines outcomes, bankruptcy does something far more significant. It changes control. And once control shifts, every other element of the dispute shifts with it. In high-conflict legal and commercial environments, bankruptcy is one of the most misunderstood mechanisms in existence. Most participants approach it as an endpoint, a collapse, a terminus. Something that signals the end of a contest, rather than a restructuring of how that contest is fought. But sophisticated observers understand something different. Bankruptcy is a mechanism, a procedural event that does not end disputes, it transforms them. It redistributes authority, it shifts decision-making power, it alters the strategic leverage available to every party involved. And there is one specific consequence of that shift, one particular change, that most people do not see coming. Once it occurs, their ability to influence outcomes is fundamentally and permanently altered. We will return to that. But first, let us understand the structure beneath the event. This channel, the Strategic Brief, exists to examine disputes the way most people never do. Not emotionally, not reactively, not through the lens of grievance or frustration, but through the three variables that actually determine outcomes in complex legal and commercial environments. Power, procedure, control. Because individuals who understand how these forces interact do not simply react to events. They read them, they position accordingly, and they make decisions with a clarity that the majority of participants never achieve. That is the perspective this channel is built for. To understand what bankruptcy actually does, we need to step back from the financial narrative entirely, because while the financial consequences of bankruptcy are real and significant, they are not the most strategically important consequence. The most strategically important consequence is this: bankruptcy is a control event. Before bankruptcy, an individual or a business entity typically operates with a relatively coherent degree of control over their own environment. They control their assets, how those assets are held, managed, and deployed. They control their decisions, when to act, when to wait, when to negotiate. They control their legal strategy, what claims to pursue, what claims to resist, when to settle, and on what terms. And critically, they control the flow of information, what is disclosed, to whom, and when. After bankruptcy, that control does not simply reduce. It does not merely diminish at the margins. It transfers. Decision-making authority begins to move away from the individual and toward a system, a set of processes, obligations, and parties that now have a formal role in determining outcomes. This is the structural reality that most participants in bankruptcy disputes fail to grasp. And because they fail to grasp it, they continue behaving as if they still hold the levers, when procedurally and legally they no longer do. Control is not a single variable. In a dispute environment, particularly one involving financial complexity, control operates across at least 4 distinct dimensions. And understanding each of them separately is important, because bankruptcy affects all 4 differently. The first dimension is financial control. Before bankruptcy, a person or entity typically exercises judgment over how money moves, what gets paid, what gets withheld, what gets prioritized. After bankruptcy, that discretion narrows. Access to funds may be constrained. Expenditure may require approval. The financial autonomy that previously existed is now subject to external oversight. The second dimension is legal control. This concerns the authority to initiate, direct, and respond to legal action. Before bankruptcy, an individual or entity can generally pursue claims, respond to claims, and direct their legal strategy according to their own priorities. After bankruptcy, that authority is not guaranteed. In some circumstances, it shifts to another party entirely. And that shift, as we will explore shortly, has profound implications for anyone involved in active litigation when bankruptcy occurs. The third dimension is informational control. Before bankruptcy, a party exercises significant discretion over what information becomes visible, what is disclosed, and what the broader narrative looks like. After bankruptcy, information flows change. Documentation is reviewed, records are examined, the private becomes less private, and the ability to manage how a situation is understood by creditors, courts, and counterparties is significantly reduced. The fourth dimension is strategic control. This is perhaps the most subtle, but also the most consequential. Strategic control refers to the ability to set priorities, timing, and direction, to decide what matters, in what order, and at what speed. After bankruptcy, strategic control is filtered through a new set of objectives, and those objectives do not belong to the individual. Most post-bankruptcy mistakes come from acting as if nothing changed. Once bankruptcy occurs, something else happens. A new participant enters the environment. In most jurisdictions, this party is referred to as a trustee, an administrator, a liquidator, or an equivalent role. The title varies. The function does not. This party does not arrive as an ally. They do not arrive as an adversary either. They arrive as something that is in many ways more significant than either. They arrive as an institutional actor, one operating under a mandate that is entirely separate from the personal interests of the individual who has entered bankruptcy. Let us examine what that mandate typically looks like. The trustee's focus is generally structured around three core objectives. First, the identification and realization of assets. Whatever value exists within the bankruptcy estate, the trustee's role is to identify it, protect it, and ultimately convert it into something that can be distributed. Second, creditor outcomes. The trustee is not primarily concerned with the interests of the bankrupt individual. Their obligation runs to the creditors, the parties to whom money is owed. And third, procedural compliance. Trustees operate within a formal legal framework. Their decisions are not made on instinct or personal judgment. They are made in accordance with process, documented, reviewable, and defensible. This creates a fundamental shift in the nature of decision-making within the dispute. Before bankruptcy, decisions were driven, at least in part, by personal priorities, by urgency, by emotion, by the individual's assessment of what matters. After bankruptcy, decisions are driven by system objectives, and those objectives may align with the individual's interests. Or they may not. This is where a critical misunderstanding consistently emerges. Many individuals assume that the trustee will naturally act in their interest. They project alignment where none exists. They share information freely, assuming it will be used to help them. They make requests, expecting them to be prioritized. But structurally, the trustee's mandate is not to help the individual, it is to serve the process. And when that misalignment is not recognized early, when the individual continues to operate as if the trustee is their advocate, the consequences can quietly reshape the entire direction of the dispute, sometimes irreversibly. And this brings us to something that determines everything else, the concept most people overlook entirely. We need to spend time on a concept that is technical in name, but profound in its practical consequences. That concept is standing. In legal environments, standing refers to the authority, the recognized legal right, to take a particular action, to initiate a claim, to respond to a claim, to direct litigation strategy, to make a binding decision on behalf of an estate or entity. Before bankruptcy, standing generally sits with the individual or the business entity itself. They are the ones who decide whether to sue, whether to settle, whether to appeal, whether to resist or to concede. That authority is theirs. After bankruptcy, the question of who holds standing becomes considerably more complex. In many bankruptcy frameworks, standing to pursue or defend certain claims transfers to the trustee. This means that the individual, the person most directly affected by the outcome of a dispute, may no longer have the authority to control that dispute. They cannot instruct legal counsel to take a particular action without the trustee's involvement. They cannot negotiate a settlement on their own terms. They cannot direct the timing of decisions that will directly affect their own position. The implications of this are significant. First, decisions may no longer be made by the person most affected by the outcome. They are made by a party who is operating according to a different set of priorities. Second, timing changes. The urgency that the individual feels does not translate directly into speed of action. The trustee operates on institutional timelines, not personal ones. Third, priorities change. What the individual considers most important may not rank as the highest priority within the trustee's framework. Claims that feel critical to the individual may be assessed as low value by the trustee, and assets or actions that the individual had not prioritized may suddenly become the focus. Fourth, the ability to control narrative becomes limited. The individual can no longer unilaterally shape how their situation is presented to the court, to creditors, or to counterparties. The trustee controls that communication. This creates a structural reality that many participants find genuinely difficult to accept. Not because they are unintelligent, but because the shift is procedural rather than visible. Their circumstances appear the same. Their dispute appears to be the same dispute. But the architecture of control beneath it has changed fundamentally. Loss of control is rarely sudden. It is procedural. Earlier in this video, we referenced a shift that most people do not anticipate, a consequence of bankruptcy that quietly, and often permanently, alters the nature of a dispute. This is it. Bankruptcy changes not only who controls decisions, it changes how decisions are made. And the difference between those two things is significant. Before bankruptcy, decision-making within a dispute, even a complex one, tends to operate with a degree of responsiveness. A counterparty makes a move. The individual responds. An opportunity emerges. The individual acts. An offer arrives. The individual negotiates. The process is reactive, personal, and relatively fast. After bankruptcy, that responsiveness is replaced by procedure. Decisions are filtered through documentation. They require assessment. They require approval. They move through layers of institutional review. Information submitted must be assessed within a framework. Dohungji's actions proposed must be evaluated against trustee obligations. Timelines that once felt controllable now depend on external processes that the individual has no power to accelerate. For some participants, this structured environment provides something valuable. It introduces a kind of stability, a slowing of the pace that reduces the risk of reactive errors. For others, and this is the more common experience, it creates profound frustration. Because the gap between the urgency of their situation and the pace of the system is experienced as obstruction, as indifference, even as hostility. But the system is not hostile. It is simply indifferent to urgency that is personal rather than procedural, and reacting emotionally to a system that does not respond to emotion does not produce better outcomes. It produces worse ones. This is the hidden shift, not just a change in who decides, but a change in the logic by which decisions are made. And those who do not recognize that logic quickly find themselves generating noise in a system that only hears signal. Consider a hypothetical situation, one that is deliberately constructed to be generic, but drawn from the patterns that appear consistently in high-conflict bankruptcy environments. A business owner is involved in a complex dispute. There are multiple financial pressures operating simultaneously, a contractual disagreement with a former partner, outstanding obligations to suppliers and lenders, personal guarantees that have created exposure at the individual level. Legal costs are mounting, cash flow has tightened to a point where normal operations are under strain, and then, after a period of escalating pressure, bankruptcy occurs. Before this event, the owner operated with a coherent sense of control. They directed legal strategy, they made negotiation decisions, they managed communications, they determined which creditors to prioritize and which claims to contest. The dispute felt controllable, difficult, but controllable. After bankruptcy, a trustee is introduced, formally, legally, with authority that now sits between the owner and every significant decision within the dispute. The owner does not adjust. They continue operating as if the pre-bankruptcy dynamic still holds. They send communications to counterparties, attempting to manage negotiations directly. They contact legal counsel to give instructions about claims, without understanding that certain instructions now require trustee involvement. They react emotionally to developments, issuing urgent requests, demanding rapid responses, within a system that processes requests on institutional timelines. The result is friction at every point of contact. The trustee, operating according to their mandate, responds to institutional process, not personal urgency. Counterparties, recognizing the change dynamic, begin engaging with the trustee rather than the individual. Legal counsel must navigate the new authority structure, which creates delays and additional cost, and the individual finds themselves progressively further from the decisions that directly affect them. Opportunities for early resolution that existed in the initial phase of the bankruptcy are missed, not because they were strategically rejected, but because the individual was operating in the wrong mode, attempting to exercise direct control in an environment that now required influence. The distinction between those two things, direct control and influence, is the difference between effective navigation and prolonged conflict. The most effective participants in post-bankruptcy environments do one thing differently from those who struggle. They recognize the shift early, and they recalibrate. Recalibration is not capitulation. It is not passive acceptance of a situation. It is a deliberate adjustment from one mode of operating to another, from direct control, which is no longer available, to influence, which remains available to those who understand how to exercise it. What does that recalibration look like in practice? It begins with understanding the new decision maker. What are their objectives? What framework do they operate within? What kind of information do they need, in what format, in order to make decisions that serve both the process and the individual? It continues with communication alignment. The individual shifts from asserting their position to providing structured, process-relevant information. They present their position not as a demand, but as a submission that serves the trustee's mandate. They document clearly. They respond promptly. They do not generate noise. It extends to timing. Rather than reacting to institutional timelines with frustration, effective participants plan within those timelines. They anticipate decision windows. They prepare submissions in advance. They position themselves to be heard within the system's rhythm rather than attempting to force a rhythm the system will not adopt. And critically, they avoid reactive behavior. Every impulsive communication, every emotionally driven decision, every attempt to force a direct outcome that the system must now mediate, all of these reduce the individual's effective influence rather than increasing it. Those who understand this dynamic achieve more, not because the system favors them, but because they have learned to work within the system's logic rather than against it. The dynamics we have examined today, control transfer, trustee mandates, standing, strategic recalibration, are not widely understood. They are not taught in general financial literacy. They are not discussed at the surface level of most commentary on bankruptcy, but they are the variables that determine how disputes evolve once bankruptcy enters the equation. This channel is built for individuals who want to operate at that level of understanding, not emotionally, not reactively, but with the structural clarity that separates effective navigation from prolonged, costly, and avoidable conflict. If that perspective is useful to you, consider subscribing. New episodes examine the mechanics of high-conflict environments with the same analytical framework. If you are currently facing a high-conflict legal or financial situation involving bankruptcy and would like strategic perspective on the structure of your position, you may make contact at thestrategicbrief21@gmail.com. Any discussion provided would be general strategic commentary only. It does not constitute legal advice. If your situation requires legal advice, you should engage a qualified legal practitioner in your jurisdiction. Bankruptcy does not simply remove assets, it redistributes control, and those who understand where control moves are better positioned to respond to it.